Have you heard about the mock trial program, but want to know more details about it? You learn that it's a trial simulation, but you want specifics. Well, the following episode will clear this up. Welcome to PA Voter Information Network. This is Larry DeMarco, your host. Are you anxious about this upcoming election season? Well, I have a cure. Just click the subscription button on my YouTube channel and all your opponents are guaranteed bad luck. This is part 2 of an informational video series for high school teachers, administrators, students, and attorneys who might have heard about mock trial but are reluctant to get involved because they think that getting over the initial hump is too steep a climb. Paul Kaufman, one of the writers of many mock trial case problems and a member of the executive committee, put together an instructional video to answer what is mock trial to encourage participation.
What is mock trial? Mock trial is a simulation of a trial experience. In some ways, it's very much like a trial. There are attorneys, there are witnesses, there are objections, there are judges, and there are jurors, although in this case the jurors are there principally to give scores to the participants rather than to render a verdict on the merits. Now, they are trying a case in an extremely abbreviated period of time. Most trials in state or federal court go hours and hours, most often days, sometimes even weeks or months. We get a high school mock trial done in about 2.5 hours, from starting gavel to the end of the case. So everything is very compressed, and everything in the trial is associated with time limits. Now, the actual simulation is done by a group of not fewer than 6 people, so you have to have 6 members on your team, 3 to be attorneys, 3 to be witnesses. Depending on your regional rules, you may be permitted to have more than 3 attorneys, but there will only ever be the 3 witnesses. Now, a mock trial proceeds more or less as a real trial does. You have 3 attorneys, you have 3 witnesses, each side is required to call all 3 of the witnesses that are in the packet for it. Those witnesses will take the stand. They will be direct examined. That means that they will be asked questions by members of their own team on behalf of the case for whom they're testifying. So if it's the police officer in a criminal case, that person is almost certainly going to be called by the Commonwealth, by the prosecution, and asked questions on direct examination that help the prosecution. Those questions usually are open-ended. Who, why, what, where, when, how. Then comes cross-examination. And as everybody who's ever watched a law show on TV or a legal movie knows, cross-examination is when the other side gets to ask you questions. They don't have to ask open-ended questions, and in fact, shouldn't. They ask very specific questions to either hurt the case of the other team or to undermine the witness's credibility by showing, for example, that the witness lied before or is lying now. The trial proceeds as a trial does in real court. After some preliminary matters are addressed, if there are any preliminary matters to address, opening statements happen. Now, there is some variation in states and federal courts about when opening statements happen, but in mock trial they always happen at the beginning. And in Pennsylvania mock trial, they are limited to 5 minutes. An opening statement is an opportunity to explain yourself, to go through what you think your case will show. Then, the prosecution or plaintiff, depending if it's a criminal or civil case, will call its first 3 witnesses. In order, they will be direct examined, cross-examined, and if the first side that called them has additional questions, you can do what's called a redirect examination. So if they gave a bad answer on cross-examination, and you feel like it's important for them to have the opportunity to explain what they meant, you can have them do that on redirect examination. And then you are open to re-cross examination about that explanation. At the end of those 3 witnesses, the prosecution or plaintiff rests, and we move to the defense. The defense then calls its 3 witnesses. The same thing happens, only in reverse. The defense is doing the direct examination, and the cross-examination is done by the plaintiff or prosecution. Ultimately, after all 6 witnesses are concluded, that's when the testimony ends, the evidence ends, and there is closing argument. Different states and the national competition do things differently. In Pennsylvania, we have the defendant close first. Defendant is given 5 minutes. Then the plaintiff or prosecution closes last, also given 5 minutes. There is no separate time for rebuttal in Pennsylvania. Now, a team also will typically have a timekeeper who's watching all of those time limits. In Pennsylvania, that means you've got 30 minutes to do all 6 of your examinations, all 3 of your directs and all 3 of your cross-examinations. However, there is one critical exception. The clock stops for objections. When the other side objects, that argument, which takes place constructively at sidebar, but actually in the hearing of everyone, that is not timed. Nor is it timed when you introduce evidence. In the case packet, you will see exhibits. This year we have 11. Some years we have slightly fewer. Some years we have slightly more. You are intended to use those documents, or at least some of those documents, to help make your case, to help substantiate what a witness is saying, to give evidence that the jury can examine. And you should use some of it. However, like everything in mock trial, we have not given you enough time to talk about everything the witnesses talk about, or to introduce every exhibit that's out there. You have to pick and choose what best fits the case you want to make. And that is one of the great challenges of mock trial.
Not having enough time to present all the facts and the exhibits adds a layer to the competition in addition to having to recite and argue simple facts. You have to prepare, strategize, and decide what evidence you want to present. You also have to plan for the arguments your opponent wants to present and try to keep out inadmissible evidence. This is the 2nd episode of the informational video series about the high school mock trial tournament. In the next episode, we will discuss more details. If you like this episode, please subscribe to PA Voter Information Network. Forward this link to an attorney friend who might want to coach a student, high school teacher, or other high school administrator who could benefit from becoming involved with a mock trial team. Don't forget to click the like button and please leave a comment. I would love to receive your feedback. Signing off. Tune in next time. Bye for now.